Well, may I just, before I resume, deal with some minor housekeeping matters?
Yes, of course.
Well, this cross-examination, as Your Honour will have appreciated, has taken me rather longer than I'd anticipated.
Yes, I thought that.
Hope to finish this afternoon, and I think I will, and I hope to finish by about 3:30, 4 o'clock. My learned friend has been kind enough to indicate that if Marina Kinderland wishes to do her presentation this afternoon after that, if there's time, then she may do that and not be in Purdo overnight, so that we can discuss anything we need to with her, which will be very helpful.
That's fine. I have no constraints this evening in terms of timing, so...
Well, that's very helpful. I mean, if we could get those two things in, that would help.
Yes.
We're then hopeful that we'll be able to deal with the technical experts, all three of them tomorrow.
Okay, well...
Maybe ambitious,
yes.
but then we can certainly deal with content. The question then arises as to where we fit in the view, as to whether you think it would be sensible and whether you would prefer it before we have the technical experts in the witness box, which would mean possibly tomorrow morning, or afterwards, which might be easier to arrange.
Afterwards will be fine.
In which case we'll arrange it at a time that's convenient. I think we may have to speak to the director of the museum, because certainly when I went there was a blocked access to get close to the facade where the public weren't allowed to go, and I didn't fancy my chances of
yes, of course, and if you need the court to help, just let me know, and I'm sure we can all to direct them.
I think that would be very helpful. I don't know what the difficulties may be. When I went, they were delightful.
Well, look, you picked a suitable timing. I have literally no constraints on my timing at all in the coming few days, working days. So
well, that's enough.
I'm at your disposal. If you need the assistance of the courts, I'm sure I can ask somebody here to speak to the museum authorities.
Well, I think that would be very helpful as well. Maybe we'll discuss that either.
Yes, of course.
Immediately after the hearing. Dr.
So before we start,
good afternoon.
Can I just make one request?
Yes, you wanted to ask me.
So, yes, sir. So we are facing some audio quality issue on Microsoft Teams, that is the video conference. However, the audio quality is much better in the live stream that court is issuing. So I was proposing we transcribe using the audio from the live stream instead of the Microsoft Teams. The only problem with that will be there will be a 5 to 6 seconds delay in the transcript appearance.
I don't know whether that gives a problem to anybody else. It doesn't.
I didn't catch the last bit.
Look, the suggestion is that the audio quality, when the transcribers hear it over Teams, is not as good as the audio quality on the court's live stream,
yes,
because we live stream to YouTube. So the transcriber is asking whether or not they can use the live stream rather than the Teams audio feed. What that means is that you're not getting an instantaneous live note. There is a 5 or 6 second delay.
I don't think 5 or 6 seconds is going to matter, because we'll be able to deal with that, I think.
Mr. Zeng, is that a problem for you?
No, not at all, Your Honour.
Okay, well, transcribe, I don't know whether you heard that, but we're all comfortable with you taking it from the live stream.
Thank you, sir. That's very helpful.
Not at all.
Dr. Fowler, good afternoon once again. Now, in voluntary disclosure, you've given disclosure of a number of documents, and it appears from those documents that the purchase order for the new CMS machines was signed in April of 2018. The purchase order was signed on April 18, but the new machines were ordered in March of 17 or April of 17. Is that right?
That's correct.
And presumably the order was signed just to secure delivery.
It takes a long time to procure a machine like that.
Yes. And it took rather more than a year to make. But it was quite clear at that stage that that was what you were going to get.
That was because of the variation imposed by BAM on Affan, and we had to be able to actually do these panels, and we knew very clearly at that point that we are unable to fulfill the variation imposed by BAM on Affan to manufacture those new panels.
Well, I want to explore that, if I may, please. You were planning a new factory from a long, long time ago.
That was a totally different issue.
And you were planning a factory that you were going to get built by Amana Contracting.
Correct.
And construction, I think, started on that.
They did the foundations, yes.
And then, without wishing to go into details, you and Amana fell out and that contract lapsed.
I would like to correct you. I did not fall out with Amana. In fact, I stayed with the owner of Amana every single weekend.
The owner of Amana is a friend of yours, isn't he?
Yes, very good friend.
And then you leased a new factory from Altair.
Correct.
And the lease for that was signed on the 20th of December 2017.
Maybe yes.
And to give us an idea of what the factory looks like empty, we have some photographs here, and I'd like you to identify this, please. Could that be passed to the witness?
Are these on the record anywhere?
These aren't on the record, but there are some on the record as well, but these are rather helpful because it's the size of the factory. One for the judge. Would you just confirm that that is a picture of the interior of your new factory?
Yes.
And indeed the machines are on the right and the left.
Yes.
And if we look in the disclosure, if you go to the bundle at 4347 and pages following that, we get passages from your counsel's skeleton argument. 4347. There we go. So if you'd look at that photograph, that's some of the machinery and some panels.
This is a CMS machine, as you mentioned.
And we'll go down to 4348 and 4349. Can we go to 4348 and 4349? Can we just see the numbers of these so that I can see them? At any rate, that's a large panel. Can you get down, please? No, I'm sorry, up, please. There's one very large panel. But perhaps it doesn't matter. We can all look at this. Those are panels in the factory. And
which factory?
The Altara factory.
Altair
factory. That's the new factory,
yes,
for which you contracted in December 17.
Correct.
And since March 17, it had always been clear that you were installing the new CMS machines somewhere, whether it was in the Amana Contracting factory, which didn't in fact get built, or ultimately in the Altair factory. You were going to have CMS machines.
Yes.
And if we look, please, at the tender, page E938, your tender proposals, 938. This is the combined bundle 938. There we go. while we're there, before we go down the page, you'll see references to the Katya, just past them halfway up, which you were referencing liberally in the tender, even though
Was not correct.
it was not correct. But at the bottom of the page, at 243, the last two lines, stop please, Afan will be implementing a new production. Can we go back to 938, please? Afan will be implementing a new production line in a new facility specifically designed to suit the production between 60 to 80 panels per month.
Yes, I did say that, but it was, you have to understand about the application of it. We, Afan, had more than one contract when we did the Museum of the Future. If I had to reserve 2 machines for the production of the Museum of the Future, I had to have additional machinery to be able to continue my work on for other customers.
But these machines were ordered in March 17,
Yes.
before the VMU 5, so before there was any prospect of any manufacture.
No, I was getting other contracts. I have many other contracts, not just this one here.
Not suggesting that you're not. But ultimately, every single panel that was put onto the Museum of the Future was manufactured with the CMS machines, not every single panel, every single large panel, of the CMS machines and in the Altara factory. There were others which were manufactured, smaller panels, in your old premises.
You might refer to our tender proposal. We restricted to 9 meter by 2 meter for the exact that purpose, that we were to use those 2 machines, reserve them for the Museum of the Future, and we had all the possibility to do that. Other projects, we could do it in the new machines. It was never considered that these machines were purchased for that until the last minute, when we had no option but to use those machines for the museum.
Dr. Afan,
Yes,
you've accepted that all of the large panels were manufactured on these 2 machines.
I accepted that most of the large ones, yes, they could not be otherwise.
Am I to understand your evidence, and is the court to understand your evidence, that had it not been for the use of the machines for these large panels, you would have used the machines for larger panels for other jobs?
Yes, definitely. That was the intention, to continue working for other projects.
Did you have other jobs with panels of the size of the largest panels of the museum?
I awarded the contract for the UAE pavilion, and we had to decline it.
But as it was,
And we, just for your information, we had also we actually did do it. That was the Majlis, or the water Majlis of His MBS of Saudi Arabia. I cannot talk too much about it. It's a secretive project.
but as it was, you were able, and you knew you would be able from March 17, to manufacture the largest panels on this project using your 2 new machines in the Altaya factory.
These machines were not delivered.
No, I know that.
Yes, so yes, I had to have a provisions in case BAM, and that what actually happened. We were instructed to make larger panels. I had to make provisions for that.
But you knew that from before you'd accepted any provision that
No.
you were going to have the machines because you'd already ordered them.
I ordered the machine for other projects, and it was our tender stated 9 meter by 2.2 meter with the intention to use the existing machines of Afan. I could not rely, because we were supposed to actually start production sometime in June. These machines would not have come till a year later.
So how is it that you gave evidence before the luncheon adjournment to the effect that you couldn't make the large machines because you had
No, I said the large
panels, the large panels, because you didn't have the room to take the large panels off the machine.
That's what I said to you. We had our tender document. We were immediately as we learned that BAM instructed us to use larger panels. We had immediately taken action to order a new machine in case for this particular variation that was imposed on us by BAM.
Come on, Dr. Irfan. You had put in your tender document at page 938 that you were implementing a new production line in a new facility specifically designed to suit the production between 60 and 80 panels per month.
That is my own position.
You knew that you were ordering the new machines.
Yes.
You knew you were having a new factory. Otherwise, this was not true.
No, what I said to you, I knew all of this one here, but my tender document specifically stated that we want to do 9 by 2.2. What I do with the other machines for other projects is my own business.
So
Not to you, not to the benefit of the museum. The museum was very clearly.
the idea that big panels couldn't be taken off the machine in your old, admittedly, spaces close to your office.
That's correct.
That was a herring, was it not? Do you know what I mean by a red
No,
herring?
I don't know.
You don't understand that.
I really don't.
It was a diversion. It was unimportant in the scheme of things.
No, that's absolutely not true, because to run a company, if you had a large project, you don't want to put all your cash in one project depending on one customer. And that's why we had implemented a second year to just keep running. The company cannot be surviving on one customer and one person. And it was very easy to tell you that we had here. So if I had smaller machine, I would like to have a variety of machines to be able to cater for even larger projects and even more prestigious projects. The fact that BAM instructed us to issue larger panels, what was only to their benefit that we were able to actually execute it.
Well, I'll move on. We'll move on to the addendum, please. Come December 2018,
Yes,
your financial position was dire.
correct.
And I'd like you to go, please, to the addendum at 1965 in the bundle. This, I think, if you go to the bottom, is a signed copy. You see your signature there, and it appears at the end of the page. And the DD is Mr. Doyle.
Yes,
And you and Mr. Doyle preceded the signature of the document with negotiations at meetings on the 5th, the 6th, the 9th, and the 16th of September, and it was ultimately signed on the 17th.
we had several meetings with Mr. Doyle during this month.
It was a heavily negotiated document, with you making points, with him making points, before you finally came to an
It was
agreement.
under threat by encashing our bonds, which were supposedly sent to the bank, and the bank contacted me to tell me, you had to sign this addendum, otherwise BAM indicated they will encash your bonds. I have a letter from the bank, from them to the bank, and the bank I think the letter is available, to show that the threats we were taken by BAM to force us to sign this addendum.
You've been in the construction industry for how long?
30 years.
And you know all about performance guarantees and advance payment guarantees, don't you?
To be honest, that's the first time I ever issued a bank guarantee.
Are you seriously asking His Honour to accept that your company has never given a performance bond or an advance payment guarantee before?
No, because we were suppliers all the time. This is the first time we ever became a contractor. And all our customers never asked for our performance guarantee nor advance payment guarantee. And I can say that on record.
You were one of the few facade contractors in the UAE.
I had a very specific, exclusive business. I could actually tell the client, this is what I could do. The reason for that, just I could explain to you, what we do, you cannot be implemented by others. Not only that, if we do something, we cannot even rectify it. It is actually a waste of money. So that's why we never give, actually. And was never expected from us to do it. But that was a big contract, and we had to issue it.
You've just given evidence a few moments ago of how often, Dr. Afan, you got bigger jobs, more prestigious jobs, jobs in
I
Saudi
did not say,
Arabia.
I said I tendered for just as many jobs as possible. I did not say I got it. This was the biggest job we had received. And to ask me that whether I had inquiries, I could assure you, recently we had just completed the yacht club and the golf club in Saudi Arabia without even a performance bond or advance payment guarantee.
Had you ever done a contracting job before where you had supplied and fitted panels?
Of this size,
No.
but we had different sizes. Not of this.
Are we talking about jobs of this size, panels of this size?
Panels with bigger or smaller. No, actually not bigger, smaller.
Smaller panels, smaller jobs.
Yes, also that was the biggest job we had.
And the biggest panels.
Yes.
So the point we just made about panels was an important one.
Yes. That were the biggest panels we made
Those were the biggest panels you made,
for the museum.
were the ones for the museum.
Yes. I think each panel cost approximately $250,000 dirham.
And the panels, as we know, came to 121 out of the 135 original quote.
If there had been a smaller or different panel, it would have been the same price, yes.
At any rate, the effect of the addendum, would you go to the top of the page on page 1965? Was that while you were going to continue to be the subcontractor, effectively the control of the works was going to go to BAM.
No.
So
Says
what do
very
you
clearly
say? What
that
do you say the effect of the addendum
The
was?
BAM had the authorities to have access to our facilities, or actually put personnel outside the facilities. BAM did have the ability, or we provided BAM with the ability to oversee how much we are producing and how much we are spending. So at least you have to remember, we signed an addendum under severe circumstances, and nobody believed that this contract could cost 250% more than what it originally was. I had to make sure we wanted to finish the job ourselves. We always wanted to, and the addendum say so as well, that BAM had to see, and I gave them the ability to see that it really did cost that much.
Well, we'll have a look at the terms of the addendum. in a
Yes,
moment.
you can.
When I was asking you a few moments ago about performance
Yes.
guarantees and bonds,
Yes.
you said you hadn't signed them. But you must have known that construction companies often come, of all levels, come under pressure from their banks when there is a threat to enforce their bonds.
It is the first time it ever happened to me, just for your information.
First time it had ever happened to you.
First time.
Had you not had it happen to clients?
I was not able to. For me, it was the very first time ever happened.
Would you like to answer my question?
Repeat that again, the
Had
question.
you not had it happen to clients?
I don't know.
Had you ever heard of it happening?
Only in a Maidan project whereby the Dubai or Maidan liquidated the bonds of Arab Tech, and that was a big, big, big issue.
And why were you surprised that when you were in such dire financial position and you weren't able to pay back, why were you surprised that you came under pressure from the bonds?
Because it was always indicated that it was a variation. They could have easily, BAM have taken a different course of action. They could have provided the facilities, we could finish the job, and they could have got our support to get their variation approved. But they have chosen a different path.
Did you not sit down with Mr. Haslam, your commercial director, and say, what is our position contractually? Let's discuss this.
Mr. Haslam had already left the company by the end of November, and that's why Mr. Nuja took over.
And you were under lots of pressure from your bank.
To sign the addendum.
And this addendum left you as the subcontractor, having agreed to execute and complete the works and the terms of the subcontract. And the subcontract, if you look at one, was to be in full force and effect. But importantly, the addendum was of the highest priority in the order of precedence of the documents making up the subcontract. And so that was going to prevail. And then you agreed that 24 hours prior to the signature of the addendum, the contractor will be allowed to place security staff and management in the facilities and regulate the movement in and out of the facilities of any asset or material necessary for the successful completion of the subcontract works.
Yes, there's nothing special.
That's
about
not just an auditing matter, checking what it's all costing, is it?
it. No, it does. That is essentially to make sure that the panels come in and the material came in and cut out of the factory where we relate the future. Simple as that. Other than that.
You were not permitted to remove any asset or material relating to the project from the facilities without the prior approval of the contractor.
Which is normal. We were working on this job, and every time we took a panel, the contractor checked it and took it out. Don't see what the problem with that.
And you and the contractor agreed that you would undertake together and agree a full audit and record of the works completed, partly completed, materials, consumables, equipment and facilities in all relevant locations 24 hours but prior to restart.
Which we did.
Context, was it not, of a significant disagreement between you because you'd stopped work.
No. Was they wanted to say, please finish the work. We understand that it costs a lot of money, and please, we will assist you in getting your variation. We will support you financially during this period of time, and you please continue to work. Which
Well,
was
we'll
very
come-
nice, if you like to see it differently, but we were under threat exactly on those terms.
There was a great deal of toing and froing in these negotiations, wasn't there, between you and Mr. Doyle?
There was not really much. They dictated the terms, and they told me they were going to send the text. I did not even make the text. And
There
it
were-
was somebody came from Holland to sign it or actually dictate it.
But you've seen Mr. Doyle's evidence on this.
Mr. Doyle was assisted by some management from Holland who came over and dictated the text.
But none of this was challenged, Mr. Doyle. It wasn't put to him that you were negotiating it at all.
I could not really, there was not much to negotiate.
Let's look, please, at clause E1, which is your first undertaking.
Yes.
The subcontractor will allow the contractor full...
on the screen. Can you help?
Could you please put it on the screen?
It's page 1966. So next page, please.
You have to wait 6 seconds.
No, that's the
That's
transcript.
the transcript.
It's longer for this.
Yes. go. Go down to B1, please, which is halfway down the page, or about roughly. Full unimpeded access and use of the subcontractor's staff. So the contractor was able to access and use of your staff.
No, because it's very clearly beforehand it says he's not allowed to interfere with our staff.
Well, how do you interpret then the subcontractor will allow the contractor full unimpeded access and use of your staff?
You could ask them questions, you could use them. I have not had time to tell them not to talk to them, but it's not supposedly to go and pay them salaries and employ them.
Will you please explain what you thought was meant by unimpeded use of your staff?
The fact my staff were actually fully committed to the Museum of the Future project, which was the case.
And that the contractor could use them to do the work.
No,
whatever happened.
No, the contractor was not allowed to use them to do the work. He had access and used the labor and the other things required for the fabrication work. The fabrication was still to be done by Afan. We are the subcontractor.
You understand that some of this is disputed and it's a matter of the plain.
It's up to you what you think.
I want to get your take on it.
Okay.
The contractor will take full benefit for the scope of works related to the Museum of the Future, only in terms of the facilities and resources until completion of the works. But you'd remain liable to obtain and maintain all legal and regulatory approvals.
I have done that as well.
Then at 4, the quality of the panels and any necessary approvals to satisfy the contract was going to remain your responsibility.
I've always done that.
But at 5, the contractor shall control the facilities.
Yes, he can. He said he had his own people outside. He had security guards outside the facilities.
That's not the only means of control, is it?
That's what I understood.
That's
and
what
that's
he
what
did.
he did.
That he could control your factories. He was in charge. That's what control means.
It's whatever you understand it, but my understanding, and he did.
He didn't have to do any more than to put the security. He wasn't obliged to do anything, but he had the power to control it.
He actually essentially controlled all the payment.
Put in place its own security measures together with the subcontractors' measures, including security guards.
He was talking about access and security guard. He was not talking about controlling of a different matter. It was you have to see it in the full
Let's
context.
go on to 6. The subcontractor shall not be allowed to blockade, embargo, disrupt, or interfere in any way with the operation of the facilities or the resources, including acceptance that no legal remedy or injunction of any kind may be raised in this regard against the contractor in respect of the facilities or resources.
We had not actually had. We wanted to finish the work. That's what we wanted to do. We had no intention of stopping or blocking anything at all. All we wanted to do is collect the money from them and finish the work. That was the whole idea.
Maybe that's what you wanted to do.
And that's what actually the contractor wanted to do as well. We
But
wanted
what
to finish the
also
job.
happened was that on a number of occasions you stopped work.
Because we had lack of that here. If he had not paid us, we were unable to continue.
You
We
removed parts of the machinery, rendering the machinery unusable.
I had the right to do in my factory to stop the work under contract agreement if the contractor did not fulfill his duties.
This addendum is the document that has precedence between these two documents.
Yes.
What did you understand by clause 6, B6?
Repeat that again. I had no intention to blockade, embargo, or disrupt.
What about disabling the machinery?
Because he had not fulfilled
No,
his...
not the because. Is that not blockading, embargoing, disrupting, or interfering with the operation of the facilities?
Yes, it did.
So what you mean is you broke the contract, but you thought that was okay because you thought they owed you money.
No. I had broken the contract. I had broken this particular clause of the contract because I need the money. It was easy.
I don't want to get involved in a protracted argument with you, Mr. Fan, but if you break a clause of the contract, you're grown up enough to understand that you've broken the contract.
Okay, if that's the case, then break the whole addendum. I have no issue with that. They have not broken the contract. If that's what you're referring to, then the addendum will no longer be valid.
So you accept that you broke the whole addendum.
If that's what you understand it, yes, it is.
I'm going to go to clause 7. I'm going to take this briefly in view of your last answer. But
Well, sorry, I don't think a witness can ask if he breached the contract wording of a particular clause. I'm not sure what.
He can be asked what he did, and he can certainly be asked whether he believed that was compliance with the contract or not.
His answer is if that's your understanding. Okay.
the management of the subcontractor, that is you as managing director and others,
As
your other
managers.
directors,
Yes.
shall remain fully available at 24 hours' notice to attend the facilities unless any longer period is agreed in writing by the contractor as requested. And then it's noted that the subcontractor has alternates for all key positions and so forth. Before the 23rd of June exercise of step-in rights, as we called it, there were still numerous occasions when you were not in charge of the works, and that was the result of that resulted in complaints by BAM.
I had to leave the country under the threats of BAM, and they had written me a letter dated, I think this 1st or 2nd of June, of April, and I consulted my lawyer. He said he advised me to leave the country immediately.
We'll come to the involvement of your lawyers and so forth later. But
Yes.
there were numbers of occasions when you absented yourself
That's
despite requests from BAM to come back. They wrote to you saying, we notice you're not signing the letters, come back.
Well, if you had removed the threats, what they had done, my lawyer had a different advice.
So you accept that you broke Clause 7 in that way, but you said you had good reason to do so because you think you were acting under threat from BAM.
Yes.
And then there's the point about employing at your own expense a claims specialist quantity surveyor from a recognised and reputable provider of such services to work on substantiation of entitlement for variations and change to the subcontract works on an intensive and continuous basis, thereby seeking to secure payment of such changes and variations as have been instructed by the contractor and employer of the project.
We had employed a consultant house to make an assessment of our entitlement and our variation, and we submitted that to BAM.
And what they submitted was an EOT application.
I don't know, to be honest with you, the exact commercial terms and how it was done. As I said, I am.
So that's commercial, is
The
it?
commercial, if Tanuja was there, she would have done that.
And then there was the point about making available key staff or alternates and passwords, because, of course, the use of the computer project, CATIA in particular, which was expensive, was absolutely crucial for the continuation of this project.
They had been able, we will continue to production. We did not stop the production.
They were making sure that you were bound to make available to them everything necessary to use your software and computer equipment.
We had continued that available, and we were able, and we continued to produce. That was evident in April, in May, and in June.
Now, I've been through the obligations that you undertook to let them effectively have control and use in the way that the contract provides. You've given your observations. What you wanted out of this was money.
Correct.
And what was agreed at C1 was that over a 7-day period, the parties will conduct a joint audit wherein they will identify and audit the schedule of costs that the subcontractor requests the contractor to pay on its behalf, the audit of the historical costs.
Yes.
What you thought was meant by that, and what was meant by that, was the costs that you had put in as historical costs for which the 15 million was to be paid.
You can see it's related.
Say that again.
It was related. We asked for 15 million on the 25th of November.
Yes.
And we requested in the addendum 15 million. It was not
And it
anything
was
to change.
quite clear that this was on the basis that that was going to be what was happening to the money, the historical costs.
If they had paid it, they would have paid it exactly the same way. But they had not paid it.
They paid 15 out of the 16 and a little bit, didn't they?
No.
Well, they paid 11, I'm sorry,
No, I'm
they
sorry,
paid
you
12
have-
and a half out of the 15.
If they had paid the rest of the money, they would have no issues. And they had to pay also the cost of running the operation. They did not do that.
Well, let's look at that.
And they had supposed to actually had paid the material at the bank to be able to have even facilities from the bank. Open the credit, but they had not actually paid it.
On the day of entering into the addendum, the subcontractor shall provide a signed, undated security check in the amount of 7 million.
That's exactly what they did.
I don't want to go through the security check procedures every time that we come to a security check.
Yes.
But this is a formal commitment to provide a signed, undated check.
And exactly what I
You
did.
signed it,
And I gave it an undated I wished.
and you knew that that was to ensure that they would have security for their 7 million.
That is their interpretation.
Now, what was your
It
interpretation?
was supposed to be returned.
And if you didn't pay,
I don't know exactly. They would come back to me, and normally, with the normal circumstances, somebody you sign an agreement with, he will inform you, I need security checks. I would have asked him, would you have paid the money? There was no need for that.
I think we've been through this, haven't we?
we have in principle. I'll go
If
on.
they had
again.
returned
I
the
wasn't going to do it as a security check.
Yes.
Then there was a commitment to pay rest, and in respect of the audit, all these costs and payment trails for these payments with future costs and payments should be auditable with complete transparency and assistance from the subcontractor and the banks of the subcontractor, and the £500 was necessary but to get them back. There were then the letter of credit on the next page,
Yes.
the letter of credit costs. And that was 30 million AED, to be identified and signed off by the contractor, and in these words, as related to the subcontract.
Yes.
What did you think that meant?
That means we had to tell them that the material done in the subcontract was that way here. And that's exactly what we did. But Mr. Doyle could not be convinced, and that was we are at his mercy.
So, Dr. Afam, are you suggesting that all of the letter of credit substantiation that you submitted to Mr. Doyle genuinely referred to items that were used for the Museum of the Future?
I do say that all the money here that we have submitted related to the Museum of the Future, we had sometimes purchased material on other projects, but it was used for the Museum of the Future, and it was explained that to Mr. Doyle on several occasions.
And your evidence on this is that you had been in delay on a project in June.
Nakhil Mall.
Sorry.
Nakhil Mall, that's a project.
And that project was in delay, so you'd used some of the materials that were generic materials.
That's correct. Not
Bought
only
for-
Dubai Mall, also Dubai Mall as well.
Bought for Jumeirah, so your witness evidence.
Yes,
And you used those for the Museum of the Future.
100%.
So the substantiation was good for the Museum of the Future.
I am of the opinion he could come and check the material that he been used, and he could have checked that we had used it, even if it was not on the invoice, say that I had purchased it for the Museum of the Future.
And then at 4, in addition to the payments that will be made in accordance with C1 and C2 from the date of the addendum, the contractor shall pay on a monthly basis any further legitimately substantiated costs staff, labour, services, materials, consumables, and other things provided for the completion, benefit, and advancement of the subcontract works, and subcontract works only the production costs. So we've got so far that your historical costs for those particular invoices were going to be paid by BAM.
Yes.
The letter of credit costs would deal with
Material.
future purchases against a letter of credit.
Purchases were already made, invoiced to BAM, not future purchases. These are incurred costs.
And they were going to be identified and signed off by the contractor as related to the subcontract.
That's correct.
And you had to prove that first.
And I did.
And then there was production costs, which we've seen, and then the running costs covered subcontractor-owned equipment, rent, maintenance, utilities, insurance, software, computing, and end transport, substantiated in support of any claim made in respect of the subcontract and at financial order.
Which we did.
And the contractor will pay legitimately substantiated running costs on a monthly basis, subject to audit for scale and credibility.
I have, just for your record, they had not paid a single dirhams. Under
But
that
they paid
clause.
all the dirhams for the running costs.
No, they did not pay any running costs. They only paid the salaries we were getting them in drips and drops from the year. And in fact, even the 15 million, they have not paid it.
They came to your rescue, didn't they,
To their
in
rescue
order
as
to
well.
keep the project going?
That was also their rescue. They had contacted several other suppliers and everybody rejected it. I know that because they called me.
So you were one, you were concerned with the leverage. You was,
I did not use it simply because of this particular project. You don't leverage against the Dubai government. Simple as that. You live in this country.
the project kept going and you weren't paying for it.
I had a lot of money requested from bank to pay, and they had not paid it.
But they were paying it, weren't they?
At one time, they paid some of the money. The running costs they did not pay. We could not even maintain our machinery.
And you were getting certificates monthly with all the contra charges.
The contract charges, because they had refused to accept that there was a variation and it cost a lot more money, but they insisted that for their clean bookkeeping, they would still use the original price of the contract as opposed to the actual really cost were.
And you had not sought to secure a variation instruction.
The
Your commercial
legal
department.
team of the commercial team, they were looking at it. In fact, the addendum had foreseen to implement it. So in other words, we had under no feeling that the contractor was not sympathetic to our variation cost. We had informed him before the variation in the end of October. We had informed him of the actual cost at the end of November. Then he requested a third party to check whether these costs were correct, and we had done that and we supplied it to him. And I would like to add that even when they took over, it did cost them the same amount of money. Our joint quantum surveyors, they found out that the £500 which are produced under AFAN and the £500 which were produced under BAM after they took over had the same cost.
Would you look, please, at the letter at 1976? And the schedule attached to that.
Yes.
This was said to be a letter with a schedule of the letter of credit costs outstanding that includes a number of payments to notice.
This is arranged by Mr. Nuja, and was correct.
We'll come back to notice in a moment or two. And on the 19th of December, the same day, you got the second payment. You got the payment of the 7 million.
Yes.
So the first payment being the one you had for the CMS machine.
Repeat that again.
You had one payment for the CMS machines back earlier in the year, and then you got the 7 million on the 19th of December, 2 days after the signing of the
No, we
agreement.
had also in between that another payment we had received them from them. That's not correct. At the end of October, we requested a payment from them, and they paid it with a data check, and they collected the check. And we had actually said it.
The first check was the check you had in May for 4.3 million
I'm
for
not
the
so sure
CMS
the rest of the
machines.
second check, but there was another check about the value of about
And then you had a
15
check 2 days after the addendum for
Yes.
7 million.
Yes, they did.
There wasn't another check in between.
No, not in between.
So why did you just say there was?
There was another check, but in between or after or beforehand, I don't know, but there was another check.
Would you look please at 2054?
Yes.
This is an email relating to the second tranche of the money that you expected, with reference to the addendum to the subcontract clause C1.
Yes.
Kindly find below summary for the payment of 8 million
Yes.
expected to be released by the 15th of January 2019.
Yes.
On there we see Qanun Labour outsourced, Al-Waha Labour outsourced, Transworld and Diab. In relation to Qanun, you'd said April to July invoices. You must there have meant April to July of 2018.
Yes, must have been.
So at this stage, very nearly 6 months after the last date,
Yes, what are you trying to say?
Al-Waha, July to September.
Actually, Mr. Nuja had actually prepared these tables. I do not prepare these tables. If you were asking me individual payments, I would not have known.
But you'd negotiated the terms of this, and this was the substantiation that you were purporting to give
Yes.
for the
Mr. Nuja-
payment for historical costs.
Yes, that
costs
means
already
costs incurred, but we have not been paid.
which was to justify the 15 million demand met
That's what it-
26th of
yes.
November. And are you asking His Honour to accept that this money, that this email, written on your company's behalf,
Yes.
was not representing that this money would be paid, this money would be used to pay these invoices?
No, I said they were paid. And that's what we did. Whatever money we had received, we paid it in accordance with this letter. Not received the full money.
Received,
Part of
you'd
it.
already received 7,
That was
and
done
of the
beforehand.
8,
Sorry, can the witness be shown who sent this email?
yes, we know it's Ms. Lathanuja.
We had received 7 million and we dispersed it. That was even prior to signing this email.
You know perfectly well that this was copied to you, and you were very much a part of providing this as substantiation of your historical costs.
If the Nuja said it was substantiation, she's the one who disperses the money anyway. So if it is that is not dispersed, if we paid it, it would have been dispersed. We had received the 7 million and we dispersed it accordingly. If you look at the 16 million on the 25th of November, and this is some of the money did not show up here. That means we had received it and we had dispersed it in accordance with the commitment we had made.
Would you go, please, to page 2129? this is a summary that was said to be provided. Would you look, please, at 4.0? This is a response to the substantiation that you had attempted to provide. And they'd been through it. Your email of the 8th of January was the email we just looked at from Tanuja.
Yes.
You then provided further documents, it was said, on the 17th of January. Teres, could you please reduce this so that we can see the whole thing if we can? A little bigger than that, preferably, so that we can at least see the width, read it. But somewhere between the two, that's reasonably good. And then, thank you very much. So if you see the Afan salary point,
Yes.
the comments are there on the 27th of January, and then there are additional comments on the 31st of January. And go down, for instance, to Canaan Labour Outsourced.
Yes.
They had asked for signed, stamped and approved time cards, which is pretty reasonable, isn't it, in respect of
Tanuja would have done that.
in
We're not
respect of
expecting to
Canaan
do that.
Labour. Not provided. Go on to the right-hand side, not provided.
So,
The red are all comments by BAN.
I really do not follow these letters. Please understand me. I have
You're
run
just
a
saying-
bigger company, but I have Tanuja to do that, and I have no reason to believe that she had made a mistake or otherwise to substantiate.
But there's no suggestion that these ever were provided, and that they're perfectly reasonable requests for substantiation, of which you were supposed to provide complete substantiation.
If we had it, we have done it. There's nothing sinister about it. We were paying people. I could see that Kanu was working in the factory. And I understand they have really been in contact with Kanu. I spoke to him yesterday.
We'll get. Sorry, what did you say?
I spoke to Mr. Kanu, and he said yes, they had contacted me and asked me to provide a statement against you.
Would you go, please, in relation to loss of to letter of credit costs, to 2002? This is the 30th of December, and it's an attempt to, or it's dealing with the substantiation of letter of credit costs.
Yes.
And what Mr. Faraz is saying is, in accordance with the addendum, FAN is obliged to provide all necessary substantiation to enable BAN to verify the costs are related to the subcontract works. However, to date, we've only been provided with a schedule of costs without the necessary substantiation. We'd expected to discuss this and other related matters with the FAN on 30th of December at a meeting requested by BAN. The FAN's requested to defer the meeting to 6th January. We also note we've raised the requirement for a FAN to provide full and substantial costs. In view of the above, we repeat our request for a FAN to provide full and proper substantiation of all costs to ensure complete transparency and auditability in accordance with the signed addendum.
We did.
But you didn't, did you?
No, we did. He just wanted to say, we told him, we had explained it to Mr. Dodd on many occasions, that there's some material we had purchased on the name of other project and we had used it on the museum.
Well, we'll
And
come to
he
that
was
in a
not
short
able
while.
to accept that. And he said, no, if you don't show me that it was signed on the name of the museum, I will not accept it. And I did mention that on several occasions. And I would be surprised that even to date, he still doesn't accept it. Maybe it is his way of thinking, I don't know. But in our opinion, it was substantiated.
At any rate, I think you accept that on the 20th of January, the third security check was advanced, the 4 million.
Yes. Should have been
and
by the
then
time we should have received 8 million by the 15th of January, just for your information.
On
but
the-
it is not.
5th of February, there was further correspondence. Would you look, please, at 2129? BAM's writing to you. Can you carry on? Revised summary dealing with the current position. That is the summary at 4370, which we've looked at. And if you go along to the right-hand side as well, this is historical costs with figures not provided, or substantiation not provided. But nevertheless, what was approved was there was an interim valuation of 12.5 million approved, subject to further additional substantiation. But from this document,
Yes.
you knew what was approved, subject to further substantiation.
I would not have known.
Your Honour, we are now dealing with serious allegation. Where
Yeah.
you is thrown around without suggesting who the you is. This is a personal allegation against this person. So can that just be clarified? And if it's being suggested that he saw this document, that
Are
should
you
be
trying
put
to
to him.
suggest that I knew of every single disbursement? I do not.
So
It
are
was
you
the
saying
Nuja.
that you didn't know that substantiation was being attempted of the historical costs?
No, I said Tanuja dealt with this issue. It was not my job. Never has been. Even payment of the salary has never been my job.
And are you claiming not to have known what Thanuja was doing?
No, I said
in
I rely
relation
100 on
to
her,
these
and
documents?
I think that she had provided all the here. It was Mr. Doyle who was just simply stalling.
If it wasn't you if it wasn't you responsible for this, how can you say it was Mr. Doyle who was stalling? These
Tanuja-
requests for substantiation are perfectly
Tanuja,
reasonable, aren't they?
I think she had provided it. She had told me she had provided it. And she is the one who provided it. And she is the one who disperses the money. And she is the one, whatever money we have received, it will be dispersed accordingly just to keep the project going.
Are you challenging the words not provided where BAM said they hadn't received the substantiation that they sought?
But whatever they wanted to seek, and we think that we have provided it, it was their opinion that it was not sufficient.
I'm asking you, because of the way that Mr. Hussain just put his point, and it was a fair
Yes.
way, whether you are challenging the proposition that documents that BAM has said not provided were in fact provided. Are you challenging their position?
I really cannot answer that question.
I want now to look, please, at, we know that the fourth security check was advanced on the 10th of February. And I want now to ask you about your witness statement, page 648,
Which one?
second witness statement, paragraph 1.4. So, I also understand Mr. Doyle alleges that I committed a fraud in issuing guarantee checks under the addendum. Although the checks were undated, meaning that it was unclear if or when they would be presented. Pausing there, you were never saying that they couldn't be presented. You were saying it was unclear if when they'd be presented.
I would have had sufficient money in the account when they presented, and actually, to be honestly, I had expected that the checks to be returned. It was in the agreement that what we had 500 panels, please return the checks. Under no circumstances did I ever expect that BAM would actually go and encash a check particularly when they knew that we had completed 494 panels out of the 500.
You say, at the time of issuing them, I had no reason to believe that they would not be honoured.
Yes,
D1 was still owed money under the addendum
correct.
and the subcontract on this project.
Yes,
And therefore, if the claimant had acted in accordance with those agreements, the account should have been in funds.
100%.
You know that from the time of the addendum, you had said that AFAN would instruct a consultant to consider claims.
We had said that we had appointed third party to check the valuation of that claim.
On any view, even in the most optimistic interpretation, it was going to take some months before there would be any result of that.
But I would have expected BAM to continue the job, to continue funding and pay the money in accordance to our claim until they had received, which they believed we were entitled to, the money from their client. I did not have a direct contract with their employer. I had my contract with BAM. BAM continued to instruct AFAN to produce those panels, knowing very clearly that there are a variation.
But you knew that there was going to be no money coming to AFAN from BAM until the consultant had not only made a claim, but established a
No,
claim
I expected
on
them
AFAN's
actually, no,
part.
that's not true. I expected them to continue paying money. We want to finish the job.
So you were just writing out these security checks on the basis of a hope that money might be due to AFAN directly from BAM on the addendum.
No, I expected them to honor their agreement with the addendum, and I expected them to actually return the checks when we finish 500 panels. I don't understand why their panels were actually even encashed. I had actually expected them to return the checks.
Even though BAM was paying AFAN's running costs,
No, they
production
were not.
costs,
No, they were not.
letter of credit costs.
No, they were not. I wish
How
they
did
had.
the job continue if they weren't?
I have no idea, because we had definitely the letter of credit cost that was not paid.
You heard Mr. Doyle's evidence.
I heard him, and he said that was not satisfied, but he did not pay the money. I heard his evidence that he wanted extra substantiation, which was actually would have been fairly reasonable for anybody else except Mr. Doyle, for that matter.
But the money was paid by BAM for the continuation of this work.
No, it's not enough. They did not pay any running costs. They
You
actually
thought-
we used the money here. They were only paying part of the salaries.
You thought more money should have been coming directly from BAM to AFAN.
Yes, definitely.
But that was just a hope.
No, it's not a hope. It was an agreement. If they did not
And-
honor their agreement,
If you didn't get money under the subcontract or the addendum, then there was going to be no funds.
no, we had other projects as well. We were expecting money from them as well. Dubai Mall, we had not paid by that time. The Khil Mall, they had not paid by that time. We had sufficient sources to many funds to come in. It just so happened that they did it, and had to
Well,
be
let's
honestly.
just look at that.
Yes,
You say at the time of issuing them, I had no reason to believe they would not be honoured.
no,
D1 was still owed money under the addendum and the subcontract on this project. And if the claimant had acted in accordance with those agreements, the accounts should have been in funds.
correct.
So there you're blaming blaming BAM for the fact the accounts weren't in funds.
Correct. They had not paid. They signed an agreement and they did not honor it.
If BAM was in the position of having to present the security checks, then BAM did not accept that it owed you money.
They would have returned the checks. Actually, anybody who had signed an agreement with you, they should have returned the
Let's
money.
leave out the question of returning the checks. You never
Why
got
not?
to the 500 panels
Why?
before they were presented.
There were 494 were finished by that time. You would be actually. It's just like I could not understand the
Can you
position.
concentrate on my question?
Yes, please answer the question. Ask the question. Sorry.
The historical costs had not been substantiated according to BAM.
according to BAM.
So you couldn't have been expecting more money on the historical costs
I'd
until
expect,
you'd satisfied.
I'd expect them to accept the substantiation and to have paid the money. It was
The
unreasonable,
letter of
very unreasonable not to accept it.
the letter of credit costs were going to be paid to the suppliers of goods against the letter of credit in respect of invoice materials.
No, that they were supposed to be paid to the bank.
Yes, to the bank,
Yes, the bank.
who
And
was
we would
paying
have
under,
had-
out under the letter of credit.
Yes, and that in this case we would have had sufficient financing from the bank. With 30 million dirhams, sufficient financing would have had.
The money was not coming to you, to
No,
your
we had-
accounts.
No, no. The money was coming to our Afan account at the bank, of course.
The money was going to be used for the suppliers.
No, the bank gave Afan financing to purchase material from suppliers and to fund the operation of the Museum of the Future. We had exhausted our financing agreement with the bank, and had BAM paid those money to the bank, our financial situation would be fantastic. We had 30 million, at least financing from the bank to continue running the project.
Which was all earmarked for payment of invoices.
Yes, these payments were paid, but we had financing. Please understand, there's a financing for the bank. That means the banks give you credit, you buy the material for it, and as soon as that happened, we had amount of money reserved by the bank for us, and you have to keep filling up that account. So had BAM paid these costs, we would have had 30 million dirham
At any rate-
available from the bank to finance our operation.
If your substantiation didn't work, that money wasn't going to be forthcoming,
It was actually, I was surprised
and
that
the checks wouldn't be on it.
it was, as I told you, it was BAM who had actually started it.
And the
Had BAM
production
actually paid it,
costs,
would not have had this issue.
the production costs and the running costs were also to be paid to meet expenditure monthly in arrears.
We did not pay it. We had even
And if
told
you
them how
didn't
much it-
substantiate them in accordance
they were
with the
not,
terms,
they were not, to be honestly, at that point, BAM were stalling in every single substantiation. For whatever reasons, I don't know. They wanted the project to finish at the cheapest possible rate. They had seen how much it really cost. They did not believe it before signing the addendum. After signing the addendum, they found out how much it really cost, and they had somehow said, why should we pay it?
Dr. Afan, I'm going to put this shortly if I can.
Yes.
Basically, you had no guarantee, no reason to be
Yes, I had. I
that
had
money
decided-
was coming from the addendum or the subcontract directly to Afan.
Yes, it was the addendum was supposed to come for the Afan.
And if there was no money coming from them because they didn't accept your substantiation,
That check would have been returned anyway.
but if they presented it before it was due for return,
That was malicious.
it was nevertheless a clear prospect that that might happen.
No, that really did not.
If it happened, it was quite clear to you that the checks would be dishonest.
We have informed them not to place the checks. We have said it on several occasions. And they had interest to finish the job. We had interest to finish the job. And the cost of it was higher than we had anticipated. They have known that. We had known that. They clearly, by instructing us to appoint a third party, they believed that we are entitled to variation. They even wrote to the client saying that they were entitled to variation. And I don't understand, even to date, why Mr. Boyle was simply adamant he did not have enough substantiation. I really don't know.
Can you explain, please, why it was that you withdrew all the substantiation in March 2019?
I never do any association. We had given him so many associations, it was unbelievable.
Would you look, please, at 2211?
Okay, could you show it to me, please?
This is a letter from your company to BAM.
Mr. Bashar Jahabi had opinion, and that's what he did. I did not know about it, and it's just for
For
information.
you'd appointed him in charge in
Yes.
your absence.
Yes. Not in my absence. I was there still.
So what happened was that he'd been in charge while you were absent. You came back, he left, and then Mr. Jahabi got put in charge again. Is that right?
I did not leave. I was here the whole time until the 2nd of April. So I
Yes.
don't understand where you got the idea that I had left.
At any rate, looking at this, the letter dated the 28th of March says, please refer to a fan letter, copy attached, which states that
Mr.
all
Shihab, just for
documentation,
information.
could you read it?
Let him finish the question.
All documentation submitted for the purpose of substantiations are rendered irrelevant, and the fan hereby withdraws all of these documents.
I have to ask Mr. Bashar why he did this letter, but must have been a commercial reason for that.
Are you really suggesting that you didn't know about this letter?
Yes, I'm not suggesting.
Would you
I
go
know.
to the top of the page, please? And the page before, which I think has a covering. Stop, please. See, that letter went to, which attached this copy, to Mrs. Aquina and 5 more at a fan.
Diana still
Doesn't
works
say
for
whether you were
Afan.
one of them. Do you think you'd be one of them?
I don't know.
Go down the page, please. Can you stop there? Can you go to 2206? This is BAM saying what you weren't doing. Clause C2 of the addendum, this is the one, setting contract, states that cost in relation to letters of credit should be identified and signed off by the contractor as related to the subcontract, all auditable with complete transparency. At the meeting held at a FAN's office on 6 January 2019, BAM provided our FAN with a list of cost substantial. Could you get that letter back, please? Cost substantiation requirements. BAM noted that all costs are subject to proof that they relate to the MOTF contract works. In respect of the letter of credit payers, the required substantiation was to include all necessary supporting documents, including copies. Could you go back to 2? I'll ask you to move down, operator, if necessary. Could you go back and stop there for a moment? List of cost substantiation requirements. BAM noted that all costs are subject to proof that they relate to the MOTF subcontract works. In respect of the letter of credit payments, required substantiation to include all necessary supporting documents, including copies of letters of credit, etc. 3, and we need to go down but keep the rest of 3. Following this meeting, a FAN initially provided 5 documents in support of cost-related notice, clearly insufficient. FAN subsequently provided further documents. However, please if I'm very slowly. Most important, no reconciliation of the documents, no delivery orders confirming receipt of the materials by a FAN report was provided. Stop, please. Raised by BAM on 8th January, despite BAM insisting that further substantiation, a full reconciliation of the documentation be provided by a FAN advised that no further substantiation would be provided. At this junction, the status of the required substantiation was as follows. Full statement of account relating to notice had not been provided. A FAN advised the orders being placed are not project specific, so an accurate statement cannot be provided for only the MOTF project. And then it goes on to purchase orders and delivery notes related to the material deliveries by notice not being provided. FAN only provided a few purchase orders. Then there's a point about reconciliation of the notice payments. Despite BAM repeatedly advising a FAN of the deficiencies in the supplied documentation as highlighted above, the FAN failed to address these deficiencies and instead attempted to coerce BAM into paying the amounts claimed for notice and then doing a reconciliation letter. Can you move on, please, a little? Can you move on a little? Subsequently, at a meeting held on 21st February 2019, which was attended by representatives of ADCB at a fan's request, this was a meeting between you personally and Mr. Doyle.
Yes, but with ADCB.
And you handed over 10 files of documents which you assured Mr. Doyle that they contained full substantiation of all the letter of credit payments for suppliers in a summarised and reconciled manner.
And we believe that was correct, and all the documents were actually established or prepared by Tanuja.
And you said, in relation to notice materials, that you were unable to provide delivery notes and materials supplied by notice specifically for the MOTF project. BAM replied it would be practically impossible to audit the documents in the absence of such critical documentation. AFAN further suggested highly likely that materials supplied from notice were used on other projects. On the detailed review of the 10 files, BAM discovered that approximately 50% of the documents were actually not related to the letter of credit payment schedule. To date, AFAN has not provided BAM with a satisfactory explanation as to why this non-related documentation was issued, which caused BAM unnecessary time in reviewing it. As it transpired, the documents were incomplete. And BAM raised the matter with AFAN at meetings on the 6th and 10th of March, whereby AFAN confirmed that the provide documentation in relation to the notice doesn't actually demonstrate delivery and receipt of materials by AFAN, and has not been reconciled or can be, that all requested payments relate specifically to the MOTF project. And then we've seen that you withdraw them. Your explanation is still the one you gave, that these could be generic projects, generic products.
Notice in particular.
I'd like you, please, to look at 2138 and 2139. Stop it. Could you go back to the bit that's stop that, please. These are notice projects which were said to be applicable to the Dubai Mall Fashion Avenue extension.
And it could be also used on the museum as well.
Well, we're going to come to that. Ms. Tanuja admitted, you've seen the evidence of this, to Mr. Doyle, that 50% of the letter of credit substantiation related to other projects.
I keep repeating myself, and I repeat myself again. We purchased material for notice on a generic basis. At every opportunity, we had financing. If we had financing regarding Dubai Mall Fashion, we would have bought it under Dubai Fashion. But it did not mean that this material were not used on the museum.
And
I repeat that again, and I said it in my witness
you
statement.
still hold to that, do you?
Yes, I definitely do.
And you had told her that she told Mr. Doyle that you'd told her that that was what she was to do, was to provide
If I
the
had said it to her,
substantiation in
yes,
relation.
that is just what we told Mr. Doyle. It is a generic material.
In your witness statement, you referred to a project in Jumeirah,
Yes.
but the Dubai Mall Fashion Avenue is in downtown Dubai, isn't it? It's not.
That is a different project. But it's also generic material.
But you didn't refer to. You only referred to Jumeirah, a project that was in Dubai, in Delay.
Yes, but there was leftover material for this particular project, and we used it.
Well, let's look at this. Witness statement 2, please, paragraph 1.2. That's page 64, I'm sorry. 64728. Page 647, I'm sorry. If you can keep this document available, that would be helpful. So what's the number of this page? That's 647, isn't it? Oh, paragraph 1.2 in this. You're wrong, forgive me, I'm sorry. It's at the bottom of page 647. This is the top of page 647. Well, I'll read it to you while we're waiting. There's also an allegation being made about cost substantiation. I'm afraid you did not understand the position adopted by the claimant. I've tried to explain the position to them on a number of occasions. As a facade producer, fabricator, projects might have unique elements such as the LEDs and the stainless steel cladding on the Museum of the Future. However, there are certain generic items that can be used in different projects interchangeably. In the case of Notus, mentioned by Mr. Doyle, D1 had ordered a quantity of materials for a project that it was executing on Palm Jumeirah. This project became delayed, and the materials would have degraded if not used. Therefore, we used the materials procured on that project for the Museum of the Future. This means that the invoices provided to substantiate the costs were not marked with the name of the project. But the amounts claimed can be double-checked against the quantities installed. Circumstances may also arise where we make an order for generic projects for multiple projects at a time, so the invoice again will be not be project specific. This is typical for business in this field. So I take it that in the case of Palm Jumeirah, because it was in delay, the Notus product would not have been delivered to Palm Jumeirah, they'd have been delivered to your store.
They were never delivered, they were always delivered to our store.
They were always delivered to your store, were they? I see. And that was true of all projects?
All.
Would you go, please, to your third witness statement, at page 700. Paragraph 4.3, when ordering generic items, the invoices are still required to refer to a project name. This is because they will be purchased under a particular line of credit. Therefore, where Mr. Doyle goes through certain purchase orders and states that they refer to the Museum of the Future project, or for instance the Dubai Mall extension project, as opposed to having a blank project name, this does not support Mr. Doyle's conclusion. Do you still stick to that?
Yes, of course.
I'd like you, please, now to look at page 2142. Thank you. That's a Notus invoice. Would you go down the page, please? This is an invoice. Could you go back up? Well, while you've got it there. That says project, Dubai Mall, canopy, and this is in respect of pre-preg epoxy glass and epoxy carbon. And then could you go up the page a little? Pre-preg epoxy glass, stop there please. Stop there please. This is the invoice, and we know that's for the Dubai Mall project. Would you go to the top right-hand corner, delivery note, stop please, DO 170018, dated 27 August 2017. Please could you go back to where you were? Down and to the right. Stop there. Thank you. Dispatch document through road transport to project Dubai Mall Fashion Avenue, Dubai.
Yes, but it was the...
That refers to a delivery not to your stores, but to the Dubai Mall Fashion Avenue in Dubai.
It was definitely incorrect. I just want to tell you, it was a material that we used to produce panels for the Dubai Mall. What would Dubai Mall do with this one here? I ask you, I'd be very interested to see, because they cannot even use it. So just because it said Dubai Mall project, it was not delivered to Dubai Mall. I would be very happy if you are here in Dubai, go to Dubai Mall and find out where this material is.
This relates specifically to a delivery. And
Yes.
it deals with a delivery note through road transport.
Yes, but it was not mentioned at all that it has to be delivered at Dubai Mall. It's not possible. Simple.
I'm so sorry. You're going to have to explain how it is that notice recorded having delivered to the project DMFA at Dubai through road transport when that was not true.
It is absolutely not true. You can even call Mr. Notice if you want to. I have no problem with that one here. But definitely this material is a generic material used by Afan to produce panels for the Dubai Mall. So I'll be very interested to see how and what basis, if this is a mistake on behalf of Notice, how would they deliver it to Dubai Mall? What would Dubai Mall do with it? This material, if it stays in the sun for 2 days, will go back bust.
And this is supposed to be substantiation of letter of credit payments under an addendum agreement dated December 18,
Very easy.
and the delivery here referred to carries what date?
27th of August,
What year?
2017.
And the manufacture of panels for the Museum of the Future started when?
April 2018.
So this could not possibly be pre-preg that was usable
Yes,
For
because we had
the Museum of the
no, we
Future.
had special fridges to keep it at -18 for as long a period as possible.
To keep it at what?
-18 degrees.
So it has to be
Actually,
kept at minus 18 degrees.
Yes. That's why I said to you, when it was delivered to Dubai Mall, it could not have been, it would have been busted.
We're going to go further through this, please.
Yes.
2145. August. Delivery through road transport to project Dubai Mall Fashion Avenue, Dubai, 4th of August. Order. Packing list, 27th of August 2017.
Yes. Could well be. Easy.
And your evidence is, your sworn evidence is, that this consignment wasn't delivered to Dubai Mall Fashion
I
Academy,
swear on that. I 100% swear on that.
but was used sometime in 2018 for panels for the Museum of the Future.
Should well be. I cannot answer you what the generic material we used. Whatever material we had left over, we used for the museum.
I'm so sorry. You need to be very clear about this.
Sorry, can I just understand, if is the factual allegation that my learned friend is putting that 2,400.3 square metres of epoxy glass was delivered to Dubai Mall? Is that the factual
Is that
case
the
being put?
factual argument, what you're saying?
That's what this document tends to suggest, yes.
I assure you that is not correct. And you could say that on a swear evidence that it could not even have been.
We need to hear from you some explanation of how your invoices and packing lists recorded false information.
It was not my packing list and it's not my invoice. It was the invoice.
It's an invoice to your company.
Yes. And it was just simply said, I think they were referring to the project name as opposed to the delivery location. That's for sure.
Is that how you translate through road transport to Project DMFA?
Yes. Through road transport, that is from Ras Al Khaimah to Dubai. The notice producers in Ras Al Khaimah.
We'll go please to 2146. Same point, date 27th of August 2017.
Yes. It's normal.
This is a great amount of material being sent in August 17 to the Dubai Mall Fashion Academy.
I assure you, nothing had been sent ever to Dubai Mall directly from Notice, and you are welcome to even
Well,
interrogate
what
me.
project was it bought for?
If it was said on the Dubai Mall project, that must be Dubai Mall project. But was not delivered to the project site. We cannot even use it there. They need the oven. They have to be put in an oven to make it in a panel.
But I thought your evidence was that if it was generic material and it appeared in your substantiation, then that showed beyond question, as per the addendum, that it was usable and used for the Museum of the Future.
Partly,
And
yes.
this proves no such thing.
No. What I'm trying to say to you is that we had generic material which we had purchased under the name of other project which we could have used for the Museum of the Future. And vice versa as well, for your information. It's a generic material. We could use it for any project as we were running ahead.
But how does this substantiate that you used it for this
Because
project?
he could have seen it and the deliveries, what we actually delivered to the museum. It was easy. How many panels you do and how much material you used on it. It could not have been that it's just like we have made the material somehow. It was so easy to substantiate.
You handed 10 files to Mr. Doyle, saying that is the substantiation of the letter of credit.
Yes, I did that.
You didn't explain to him, don't worry about the fact that some of these deliveries
I did.
were more than a year ago and were for a completely different project
I
and
did.
appear to have been delivered to Dubai Mall.
No, I assure you that was not delivered to Balmore, that's for sure. But I did explain to Mr. Dole that this is generic material, could have been purchased under different lines of credit, and it could have been easily used for the museum, and vice versa for your information as well.
Let's look please at 2160 and 2161. This invoice, also from Notice, has final destination DIP Dubai. DIP is the Dubai Investment Park.
Yes.
That is where your
Factory
office
is,
is
yes.
and your factory is. And that gives you as the customer and says where you are.
Yes,
And that was also for the DMFA.
yes.
But there it says it's dispatched by road to final destination Dubai. in accordance with what you said.
It's always by road. How do you transport things from Ras Al Khaimah to Dubai?
I
It's always
don't
by
think
road.
you're picking on a very good point, if I may say so, Dr.
You are
Arfan.
picking on something that is, I could assure you, it is not correct. This material, is generic material, goes in the layup in the here. I can show you even the way it is made, and it goes in an oven. Dubai Mall does not have an oven to manufacture on site. So you are picking
Could
on
it be, Dr. Arfan, that the reason you withdrew all the substantiation in March was that one of the demands was for delivery notes,
I really would not know.
and you didn't have any delivery notes, did you? You had invoices, which happen in the top right-hand corner,
I really
to
don't
refer to delivery notes.
I could not answer that question, but the easiest way for substantiation to the panels we were producing.
That's a different point. Mr.
Yes, but what
Dr.
I
Arfan.
point out to you, I did not do that. I was not able to do it, and I will not answer your question. It was Mr. Bashar who withdrew it at his own. For whatever reason, I could not tell you.
And how do you square this with the fact that the pre-preg for the Museum of the Future is unique?
It was not unique.
Well,
It's all the same.
let's look, please, at what you said, both yesterday in evidence and at page 700 to 701 in your witness statement,
Yes.
and reconcile the two.
Please go ahead.
There's the witness statement. But you explained at 2537, please.
Which one is this one here? Is there one?
This is your witness statement
Okay.
of 4.3. You're saying where Mr. Doyle goes through certain purchase order states they refer to Museum of the Future project or Dubai Mall Extension project. That doesn't support his conclusion. And I now want to look at page 2537. This is a letter you wrote on the 15th of June, and we looked at it yesterday,
Yes.
and it was about pre-preg.
Yes.
Go down the page, please. So, I think up the page a little further. Thank you. Panels of the Museum of the Future use epoxy prepreg, having fire retardant properties. In fact, this prepreg is the first of its kind in the world and was specially developed for the Museum of the Future.
Maybe I was trying to make a statement, but it was the prepreg was specially developed for the museum, and all the prepreg we had fire retardant properties.
It wasn't generic at all, as you explained at some length yesterday, was it?
No, it was a generic.
You said nobody had used prepreg before you in the Museum of the Future in your evidence yesterday.
No, I said to you very clearly that I found out that Premier uses prepreg for the clock tower in Mecca.
You later found out that others had used prepreg.
Yes. It was not from Penotis, from somebody else.
But the proposition that you put, that prepreg was a generic substance that you could haul around from one project to another, or reassign from one project to another, is completely inconsistent
That's absolutely
with
not
what
true.
you said in this letter.
It is absolutely not true what you say.
Oh, really?
Yes,
Explain why not.
because it was used on the Dubai Mall. It was used on, I can tell you that the Rolex facade. It was used on the Versace facade inside Dubai Mall. It was used on the Nakheel Mall. It was recently used in Saudi Arabia. It was used, obviously, for the Museum of the Future was our largest project. We must have done some smaller projects in between. It was also used for the project for His Highness MBS in Saudi Arabia. So we had used it. It's a generic material. Notice it's a manufacturer of prepreg.
Would you please
And we
just
are
go,
users of
would
that.
the operator please just go up one paragraph without any more? It's fine, thank you, stop.
Yes.
This is you writing, and I want you to tell His Honour whether this was true or false.
Yes.
I would like to put on record that the production of panels of your Museum of the Future is very specialised, and neither BAM nor its partner have the experience nor the skills to carry out this task. In the following, I shall give some details. The panels of the Museum of the Future use epoxy prepreg having fire retardant properties. I think you told His Honour just now that all prepreg has fire
No,
retardant.
all the feedback used by AFAN.
All prepreg used by AFAN has fire retardant
Yes.
properties. In fact, you said to Toby in this letter, this prepreg is the first of its kind in the world and was specially developed for the Museum of the Future. True or false?
We were developing this prepreg while we were getting the bid in at 2016. So the development doesn't mean that we only produce it for the museum. We were developing it. It is an AFAN notice development. We had been used primarily for the Museum of the Future, and it was used on many other projects by AFAN.
Especially as not primarily.
It was specially, yes, for the museum. It was especially when we did it at the time. Because without it, you could not even get the approval to actually use it on
Could
the
you
museum.
just look a little further up the page at the date of this letter? Without losing paragraph 2 if you can. Can you go up the page but try and keep paragraphs 1 and 2 on the page?
Yes.
The letter to Toby is dated, but you have to go up the page a bit. Further up, please. The top of the letter. It's dated the 15th of June, 2019.
I was outside the country just for information.
You making a point to Mr. Fagan, Mr. Borley, and Mr. Killer.
Yes.
Go to the bottom of the page, please. Go right to the bottom of the page, please. The bottom of the letter. So one page down. That is your signature.
Yes. I had
This is
somebody
your
sign it.
letter.
Yes.
You are trying to persuade Toby and the other addressees of this letter that BAM shouldn't continue with any production because only AFAN could do it, because the prepreg was specially developed for the Museum of the Future and was unique.
It was done, and to your information, this particular one, the material was taken from AFAN factory to fabrics by BAM.
Your evidence has been that the materials in the invoices were used for the Museum of the Future. That was the point
No, I said
of
it
the
was
substantiation.
it was a generic material purchased on different line of credits, and they could have been used, and they were used primarily. And
There-
Mr. Doyle,
Yeah, as I see it, there are two different issues.
okay, please.
Leave for aside the question of whether there is generic prepreg.
Yes.
Leave that to one side.
All right.
And the invoices and so on, we'll come
Yes.
back to that in a moment. But what I'm interested in at the moment is that when you wrote this letter, were you developing, had you developed a technique with generic prepreg that was unique to...
There's nothing for generic. It's a generic material.
Yes.
The prepreg was developed with Notice together. Prior, Notice is a manufacturer of prepreg.
Prepreg is a well-known material.
Yes.
It's been it's used in lots of different...
Yes, primarily in the
uses.
aircraft industry.
Absolutely. So
There was nothing special about it. All
nothing
it is,
special. about it. So what exactly the point I'm asking you. In that case, what does specially develop for the Museum of the Future in this letter?
Right. First of all, prepreg were done by special manufacturers. Only Notus produces prepreg in the UAE.
Yeah.
Nobody else.
Okay.
And if you were to purchase prepreg from a different countries, you have to ship it in refrigerators. So we went with Notus. They said, could you please prepare prepreg for us using epoxy resin actually, and using fire retardant material in it. All our project being a building business. Most of the people has
So
not
all of the prepreg you use for all of your projects has fire retardant.
Yes, it has to.
So it wasn't specially developed for the Museum of the Future. It was developed for any project you used.
No, but we had at the time we knew that the Museum of the Future was coming, and we had a large quantity because Notus had to be persuaded that there are going to be huge orders after that to develop this product with us. You cannot just go ahead and develop a product assuming there was
No,
no
I
order.
understand all that.
Yes.
I'm still slightly confused by the word specially.
Yes.
But there it is. Okay,
Okay.
that's reference.
Right.
Thank you.
Can you explain when it was specially developed?
About 2 years beforehand. If it was 2019, it would have been at least 2 years beforehand. In fact, the first test we had done it was 2017, prior to receiving the letter of intent from the Museum of the Future. In fact, we had not signed the letter of intent had we not passed the test, because we could not have actually offered the material.
I put to you a few moments ago that you withdrew, perhaps a little more than a few moments ago, that you withdrew all the substantiation on the 31st of March, 2211.
Mr. Bashar had to do it for
22:15.
commercial reasons. I would not.
You don't know why that happened.
No.
On the 3rd of April, I think it's 2833, no, maybe 2216, please. It's the 1st of April. This is when you have the agreed plan of action.
Yes.
That immediately following the withdrawal. And who attended this meeting?
I was in this meeting. You remember the withdrawal must have been actually, if you look at it.
Could you speak up,
just before.
please?
Sorry. I was attended that. Yes, I did attend that meeting.
And then, a short while later, you stopped work again.
No, I had left the country.
And you left the country and you stayed out of the country, is that
Yes,
right?
I did.
Coming to the 23rd of June,
Yes,
you hadn't been in the country then since the beginning of April.
correct.
Would you go to the letter at 2711 to 2715, 3rd of June?
Okay.
2711. And if you go down the page, that letter records the earlier letter. And I'd like you to go down, please, to the earlier letter, which starts, it's the letter of the 23rd of June, it starts halfway down 2712. Dear Anna, it's a personal letter to you.
Yes.
Within the past 30 days, we've recorded numerous instances of our fund's failure to comply with its contractual obligations as evidenced by the following formal correspondence, and I don't propose to go through all that correspondence, but there are a number of letters of complaint of breaches of the contract and of the addendum, and they reach you in France, and you can see them summarised below that in the letter.
Yes.
Could you go down the page, please, operator, a little? Operator, could you go down the page a little? Stopping that. So, unauthorised suspension of the facade works. You agree that that happened on a number of occasions?
No.
You don't?
No.
So it's your evidence against Mr. Doyle for that?
Essentially, yes, we did not suspend the work. We maybe have slowed down. It was Bill who was in charge at the time, and I was not here.
He's there, you weren't,
Yes.
you said didn't happen, and he's got it wrong.
I had evidence that we were supplying and we were delivering, and you could see that evidence. So it could not have been suspended.
Letters that talk about suspension, in spite of the fact nobody ever denied it at the time, you say we're all wrong.
Which
I
letter?
No, I'm not good with him.
I,
Well, then, how can you ask that?
you were asking there. And
You're saying that the works as far
as
were
far
never
as I
suspended.
was informed by Bashar and Tanuja, we continued the work.
Well, that's your answer. Failure to provide sufficient labour and supervision to progress the contract work in breach of clause 4.2. That was a complaint that was made against you.
If they had paid the money, we would have actually supplied. This was a matter of money. That's what it was.
So you accept that that happened.
I did not accept it. I said it was informed to me by Bashar and Tanuja. They were trying their best to manage with the funds they already have. And had BAM supplied more funds, we would have even increased. We wanted to finish the job. We were not here to delay BAM.
So I want to get this clear. You accept that it happened, but you say the only
I did not
reason
say-
it happened.
I do not accept it that happened. If it did happen, that would have been the reason for that. And I assure you, we had zero intention as AFAN to suspend any work. We wanted to finish the job and get on with life. And all we needed was BAM to honor its obligation under the addendum.
Is your position about failure to provide labour, failure to proceed and complete, failure to use facility? Well, no, that's a different point. But everything to the top of the page, you're saying, I wasn't there, I was told the works were going on, but if they weren't going on and if there was a breach of contract, that was because I didn't have any money, or AFAN didn't have any money.
100%.
Then failure to use the facilities and resources solely for the purpose of the museum and the future facade works.
We did not have any other contracts, so I'm not so sure what you'd refer
Did
to.
you have any other jobs on at the time?
At that time, no. We had actually solely, in accordance with that, we really devoted all our energy to finish this contract.
Failure to allow the contractor control of the facilities in breach of clause A5 of the addendum, and unauthorised blockage and disruption to subcontract works at the facilities in breach of clause B6. You accept, do you, that there was sometimes disruption of the machinery?
Could well be, simply we just ran out of money. Maybe we could not even repair the machine. I don't know. I was not even here. What I'm trying to tell you is that had BAM honored its commitment towards the addendum, none of that would have happened. There was no even
Failure-
reason to be here in the court.
You kept BAM personnel out of the facilities, or your people did on a number of occasions?
I was not out.
You were outside the country?
Yes.
There's no evidence about that apart from Mr. Doyle's.
That's the only evidence I have.
Blockage and disruption again. Panel calculations I don't think we need to look at. But the deactivation of the CMS machines was very serious, wasn't it?
If they could not activate it, yes, it would be deactivated. I mean, if you were unable to pay the salary of the
Would you
the
go down the
operator,
page, please, down
how
to
can you
793?
operate it?
I think your position is you're able to give no direct evidence on any of this, are you?
No, I could not. I was not here.
Do you accept in general terms that your absenting yourself was a risk for the project, going to France?
Not really. I was not particularly involved in that project on a day-to-day basis at that time. It was simply all the design was made, was continued, finished, and it was a matter of production. All I had to do was simply collect the money from BAM and pay the salaries.
Do you accept that in practice BAM was paying everything that was paid in order to take the project through to completion?
Not everything.
What were you paying?
I was paying the staff.
The staff were paid directly by BAM.
No, they were not. They were paid by Afan. And BAM said until after they took over. They
No,
were
we're
paid
talking
directly.
about after the 23rd of June now.
Yes, by that time they had paid everything. They broke every single law in the contract.
Sorry, I didn't hear that answer.
They had simply employed my staff in contradiction of the addendum.
But they didn't employ your staff. Your staff was seconded to them and you were still the contracted employer.
It is your interpretation. The reality of it.
They paid
were
your staff on
directly-
your behalf.
Directly.
You were charged contra charges on the certificates, monthly certificates, of which we've seen one.
Yes.
Did you ever look at those certificates?
No. It's not my job.
They came to you, though?
No.
You didn't even ask your commercial staff?
She would deal with it herself directly. She's her job, not mine.
When you went to France,
Yes.
you were pursued by a number of debt collection agencies, is that right?
No.
Were they not after you for money?
Maybe they were after Afan for money, but not me personally.
So what you're saying is that the claims were against Afan, not against you.
No, the only person I gave personal guarantee, ADCB, and they did not pursue any claims against me. I had no personal guarantee to anybody. I had the company.
Mr. Haslam and Katya Pastro sued in the Dubai courts. Was the defendant Afan the company?
Yes, not Afan.
And they succeeded.
Yes,
Were they paid?
no,
You've had a number of travel bans imposed on you by Dubai courts.
recently, yes.
You said in evidence, more or less in the first few questions that asked you,
It's true.
that was because of BAM.
Yes,
In fact, BAM has not sought or obtained a single order posing any travel restriction on you at all, has it?
I meant the fact that because of the case with BAM, we were entitled to money. We have not received the money. The only reason I had any court cases against me is only commercial, not me personally, just for information, against the company. And I am the general manager of this company, and according to UAE law, I was supposed to stay in the company. I could operate the company. That's what I'm doing. We have 70 staff of the original staff of Afan back again at working at Afan. In fact, that was the only reason I could even fund this particular court case.
So that because of BAM doesn't refer to BAM getting any travel bans.
No,
It refers to your being sued, or your company being sued, by former staff and other creditors
that's correct.
who got travel bans against you.
Yes.
And you attribute that to the difficulty you had under your subcontract, your company's
That's
subcontract.
what you hear in
with
court.
BAM. So saying these travel bans were because of BAM is a shortcut that's
It was a shortcut, yes, that's what it meant.
And
Because
it's
of
really-
this particular court case,
misleading, isn't it?
I would not say misleading, it was the intention. If I misunderstood it, I'm sorry.
And you were arrested on your return to Dubai, is that right?
No. That's not correct.
You deny that, do you?
Yes, I do.
Because of judgments against you for bounce checks, not from BAM, but from others.
I'd settled those checks.
Were you not arrested as a result of the bounce checks, which was a criminal offence then?
No. For your information, this check idea is actually no longer applicable in Dubai.
You're speaking very slowly,
This check,
very softly.
this check is no longer applicable.
The law's changed. In
The
part,
law
yeah.
has changed. Yes.
Some of Afan's assets were seized by creditors and sold at auction. Is that right?
I think 11 cars. That's it. And we have attachment against the factory by the bank. But we are able to operate the factory. It was not put to auction.
One of your cars was impounded at a Dubai port as you were attempting to export it to go to France with it.
No. It was in France before that.
It was already in France, was it?
So it cannot
But it
have
was
been.
nevertheless impounded.
No. That, I assure you that was. I'd be very happy to show me the impounding.
Was that a Ferrari or a Porsche?
So, Your Honour, do need to object now. This is not part of the pleading case. Witnesses don't come here for mudslinging, for which there is no factual basis. There has to be some
There
self-censure.
does have to be some relevance.
And I will refer the court to Rule 38 of the rules.
Okay.
Thank you.
Just for your information, the Ferrari and the Porsche are in France. They had never been impounded. We drive them every day. My wife drives them. If you want to see pictures of them, you can send you one.
They're in France, are
Yes,
those
they
two
are.
cars?
I can't really see the relevance.
Is that Dr. Afan is sued personally for behaviour that is dishonest.
What is the factual basis of you saying he's being sued by other people?
I'm putting things on instructions.
But
That's
well,
not-
whether you're instructed or not, at the moment I can't see the relevance of whether or not he owns particular cars.
It was the fact that they were impounded as he took them out of the
I
country.
assure you
But
they
if,
were not.
if he
He's
says they
denied-
weren't,
he's
denied that, so
unless
I'm
you
bound.
can, unless you can give evidence to contradict that.
I'm entirely bound by his answer, Your Honour. I accept that.
Yes. So
It's of no evidential weight now. If he'd admitted it, of course it would have been.
Well, he didn't. So
He didn't, so end-
shall
end
we
of
move
story.
on from Top Gear? Yes.
There's only there's only one more point, is that you've had a number of court cases filed by creditors and former staff, and the creditors include Canon Engineering, is that right?
Yes, correct.
And they've achieved judgments against you.
Yes. And we're settling with them as well.
Well, that's all I ask.
Thank you very much. Well, it's bang on at 4:30. I suspect, Mr. Hussain, you're going to be longer than an hour in re-examination.
Probably not longer than an hour, but
It'll be
longer than
substantial.
15 minutes. Sorry if that was sarcasm, as I usually get from judges, but I think
No,
you genuinely-
I'm not in the least sarcastic, except about Top Gear. Maybe I apologise for that one. But it's going to be at least half an hour.
Yes,
I
I'm
should have
afraid
thought.
so.
I should have thought about an hour, but there you go. So I think we're going to have to rise now and reconvene tomorrow morning. Now, what that means, Dr. Afan, is you're still on the witness stand overnight. By all means, speak to your wife. But don't discuss your evidence with anybody else,
Ben,
please.
I'm still not discharged.
You're discharged till 10 o'clock tomorrow morning,
You can't speak to your lawyers yet.
and you can't speak to your lawyers.
But tomorrow morning, I don't have to be in the witness box.
You have to be in the witness box again at 10 o'clock because Mr. Hussain is going to ask you some more questions.
Okay.
Okay, so you will be speaking to one of your lawyers at 10 o'clock tomorrow morning,
I will
but
be.
in terms of re-examination.
Yes,
Okay.
I'll be. No problem.
Okay, in which case we'll resume 10 a.m. tomorrow morning. Sorry, just in terms of housekeeping, Lord Marks, I think that the schedule that you discussed when we started the session at 2 o'clock, I've gone out of the window.
Slightly, yes.
Yes. So maybe, again, the two of you might like to think overnight where we are.
I think we're still relatively hopeful that we're going to finish on Monday. Because we think
I
Quantum is not
have my
going to
doubts about that.
I see the difficulty.
Yeah, okay. All right, see you tomorrow morning.
Thank you. So, Dr. Afan, we'll let you leave, and then we'll
Okay.
have a good evening.
trying to
What
phone.
is it? Let me just look at it from the outside.
The judges don't need to hesitate because it's like this.
I think it might be beneficial to potentially have the experts first and see if there was a need for him to go and look at it. I understand
I
from
think
Lord Marks.
can you not just see from the outside? No, thank you. He's looking from the outside. Why does he need to?
I understand from Lord Marks that there's a portion of it that to get up close, you're not allowed to cross certain, as they boomed off the security.
I think there's the grass mount. There's actually a set of steps that goes up, which you can't. It's not public access.
So you do from the road, but I'm not sure if that's helpful to get up close.
The Lord judges anticipating the scene. There's also the viewing platform from within the centre, where you're relatively close to the panels, but it very much depends on what you want to see. Possibility of airlines, then you stand down on the floor, so on ground level.
And my concern is Thomas wants to know what he wants to see organising a big outing.
I think he indicated that would be after the hearing that he would go. Right? He said it would be after Monday that he would go. He wouldn't need me and Jonathan here. So then you can, so then you can go. You can arrange it. I think we can tell him to give us a thought on Monday what he wants to do. But I think what he wants us to do is agree whether we want him to see it. That's our expert.
I got the impression that he wanted normal viewing that we should go, but
So I was just saying, Lord Marks, we can try to make inquiries and getting to speak to a museum director is proving difficult. It's apparently a generic email box that you then sort of hurry up and wait for a reply. So tomorrow night might be ambitious.
I think we need to recheck the transcript, but the notion of doing a site visit goes from the line of questioning about cutting versus scoring.
Yes.
So I don't know if that's something that can be explored with the experts, and then, like you said, if there are any questions arising from that where he feels like he benefit from the site visit, that might be the way.
yes, let's see if that's.
If it's the fact that he wants to go and have a general look, we'd arrange it and he'd be willing to go by himself.
Well, indeed.
Is your expert based here? Your technical person?
Not the one on hexagonalisation.
But
He's from the UK. The one on panelization.
Austin is based there as well, so we
It
go
may
with them.
find a way to.
I don't think that's quite flexible.
I got the impression that he wanted us to. I can't actually.
No, there was a point with us two.
Yes.
No, because when you said we can do it before Monday, it doesn't have to. I'm sure he said it doesn't have to be before Monday or something like that. Did he not say that?
There's also a problem about a Dutch state review on his own.
No, but DLA and Horizons can go.
So what we're thinking of, Mark, is potentially a technical evidence because Marina and Mr. Smith are here.
Yes.
The judge were to go, excuse the parlance, South African Training Inspection in Loco with DLA, Horizons, Marina and Mr. Smith.
Yeah.
And that might give us a bit more time to arrange it.
The problem is tickets are always sold out. I know even going just as general admission would be very difficult. If we were to just try and turn up and take a look around the viewing platform, it would have to be specifically.
Yes, I think it has.
Particularly as we may want access to areas not usually accessible. But please continue, but I actually think this is an idea that we fleshed out project a bit more.
Also, perhaps in Chambers.
Yeah, I mean, he's at the Shangri-La, right? So he stops on the metro if he wants to go and look
I thought it'd be a nice
himself.
walk. My wife works at Climbing Coach. She picked me up last night and we went up and we drove right underneath it, and that's about as much as I ever want to see about this structure again in my life.
Well,
right,
we'll see you tomorrow.
Yeah.
It seems to be there's probably a series of discussions as matters advance.
We'll send emails to the generic inbox in the meantime and see what we can.
Yes. Just trying to think if there's any other contacts we might have.
I've checked with BAM, they don't seem to have anyone. And unfortunately, the museum director, from what I can see on the website, has just changed to somebody within the Royal Circle. So I'm not sure that it's going to be ready, available access to this human.
There is a possibility that Dr. Anfan may have contacts from the Future Foundation. So naturally, I can't ask him.
Of course,
so,
of course.
and
that all feeds in my. I don't believe this is going to happen.
no. Perfect. Thank you.
Thanks, Paul.
Sorry, I have to speak to Bridget. Do we know what time we finish?
4:30. Yeah, like bang on.